Good afternoon and welcome to today's webinar. My name is James Vann, and Ian Richardson and I are here together, somewhat practicing social distancing, but we're thankful that you are participating with this webinar and hopefully you will learn something. So our goal today is to hopefully help enlighten you a little bit in case customers file bankruptcy, what that means for your business and how you need to protect yourself. Couple of homework things that you're familiar with is obviously if you have questions, you may submit those by email to webinar@vannattorneys.com, or you can use your control panel on the GoToWebinar screen and submit them that way. And we really want to make sure that we're here to help you today. Also, two other pieces of business just for your information purposes is we're going to be having our next webinar on June 25th. If you have a topic that you know you want us to cover, please let me know. Just shoot us an email. We'll be glad to consider that. And also, we're going to start a podcast that we're hoping to roll out. No, excuse me, we're going to roll it out in June, right?
That's the plan.
We're going to roll it out in June. So we'll disseminate that information out on our mailing list. But again, the idea is to hopefully have topics that you can listen to at your leisure on a podcast, and all be business related, credit minded type, business related or litigation type data and information. So hopefully that'll be helpful to you. So we're going to hopefully advance the next slide and see. There we go. All right. So topics for discussion today. We're going to be talking about what happens if your customer does file bankruptcy. How do you respond? What do you do? What's the automatic stay? What is that? What's the claim preparation look like? How do you prepare that? And then for preference claims, what do you do? So those are sort of the things we're going to be talking about. And obviously looking at the automatic stay is part of that. So Ian, do you want to lead us off in the automatic stay part a little bit?
Yeah, absolutely. So the automatic stay is something that kicks in as soon as someone files bankruptcy. It's part of the Bankruptcy Code, Section 362, which provides, with certain exceptions, for an automatic stay of actions by creditors and other entities which would affect the debtor, property of the estate, property in the possession of the estate. So basically, it's designed to provide some protection to creditors and also some relief in the short term for the debtor. Again, the purpose of the automatic stay is to preserve the status quo, making sure that no creditor gets ahead of any other creditor. And the automatic stay is not applicable to third parties such as guarantors and general partners unless it would affect the debtor's right to recover property of the estate. Similarly, the automatic stay does not apply to co-defendants, and actions against co-defendants will be allowed to proceed. So if, for instance, there's litigation ongoing where there's a business with two guarantors, if either the business or one of the guarantors files bankruptcy, that litigation isn't stayed entirely. It's just stayed as to the person or entity that files bankruptcy. In order to get a complete stay of the litigation, all of the parties to the lawsuit would need to have filed bankruptcy.
And sort of think about it this way: the automatic stay says, from the bankruptcy court's perspective, they want all the creditors to sort of stop pursuing the debtor, so that everybody can sort of, I hate to say fight over the money they receive, but really it's to make their claim all together in the bankruptcy court, and no one gets a benefit by moving faster or quicker in state court without everybody else being part of it. Just sort of maintain the status quo again.
Exactly. That's about the only really real advantage to creditors is if you hadn't already commenced litigation against the debtor, there might be something left for you. Unfortunately, if you had already gotten fairly far in your regular litigation, if someone files bankruptcy, it can really put you in the same boat as everybody else.
Yeah.
The automatic stay is applicable to all bankruptcy cases. and it applies to all creditor and third-party actions which might affect the case, property of the state, or the debtor. All forms of secured creditor actions are stayed, including judicial actions, recovery of collateral, and foreclosure, and an action on secured debt. Informal actions such as repossession, power of sale, foreclosure are also included in the stay. With some secured creditors, you can seek relief from the stay, but if you're an unsecured creditor, so for instance, somebody that's provided goods or services on an open account, it's really unlikely, if not impossible, that you're going to get any relief from the stay.
We're going to talk about secured or unsecured today, hopefully. So part of that is, let's say you've got a deed of trust or a deed against property from someone, from one of your customer that files bankruptcy, and you say, wait a minute, I want to go ahead and get my asset protected, right? Or if you've got, just say, a lien on a vehicle or some kind of equipment, you could make a request of the bankruptcy court for a motion for relief from that stay. That is, hey, I want my stuff back. I want my assets back, so that you can try to recover that. And that's sort of what you were talking about when you said that you could go against the assets. Since there is an automatic stay, you can ask the court for permission to go after that stuff as well.
Right, but you absolutely are going to need to be a secured creditor to make that type of request. And
we would rather y'all be secured than unsecured, but
yeah, it's getting harder and harder to do.
Yeah, that's right.
So the stay includes most forms of civil action, litigation. It even includes appeals. Interesting situations arise whenever somebody has posted an appeal bond, so that gets a little bit complicated. It also includes less formal methods of dispute resolution, like arbitration or administrative proceedings. So what we typically tell people once a bankruptcy has been commenced, we tend to be more conservative than probably a lot of folks, but the bankruptcy code dictates what you are not allowed to do, and it precludes creditors from sending demand letters, collection telephone calls, collection attempts, and other harassment and or threats of filing a lawsuit. What I usually tell clients, just to be on the safe side, is if you have to ask if you can do it, you might as well just not pursue it, because usually the potential reward is far outweighed by the risk.
And also along those lines, and a lot of people say, hey, look, should I send my invoice? And I think even that is really stayed in the bankruptcy court. Once you get the notice that they filed, you really shouldn't even send an invoice to them anymore, or summary of account. You just stop at that point.
Yeah, and bankruptcy is kind of a slow process. So once the bankruptcy has been filed, there are going to be some opportunities to prove up whatever claim or claims you might have had. There may be an opportunity for an adversary proceeding, all sorts of different opportunities to get your claim out there. So I think laying low on the front end is usually a good idea, just to see what all is involved in the particular bankruptcy. Just a practical point, if a creditor is considering some action against the debtor, property of or in possession of the debtor, it's best to seek the advice of an attorney. You need to really look at the bankruptcy code, which is quite complicated, and the case law that tries to interpret it before you take any type of action. It's also a much better idea to seek the relief requested and ultimate relief from the stay from the court, rather than run the risk of violating the stay.
So one of the things the court has authority to do is if someone violates the stay, and the bankruptcy courts, at least in North Carolina, are pretty consistent with, they expect people to follow that automatic stay and not to do anything. There is some forgiveness in some areas of understanding, but I have seen some bankruptcy court judges in our area hammer people when they violate that stay. We had a case, I think it was really last year for the most part, and maybe the year before that a little bit, where our client in another state took action against a debtor, and I don't think they really knew that the debtor had even filed bankruptcy. They did not get notice, but then they were doing this in another state. once they found out, they hired us, and the other side made quite a loud stir at the bankruptcy court that our client had violated the stay. They filed motions for sanctions against our client. So we were digging out of the hole, sort of, actually a lot when we first got started. So the reason I say that to you is this: you may not even know that the customer filed bankruptcy, but you got to be really careful. The courts try to look at it from a systematic standpoint and a date time standpoint, but in that case, they just about got hammered hard because of it. So be careful if you do know they're in bankruptcy, and this is not one of those times where it's good to ask for forgiveness versus permission first. So
yeah, absolutely. Since the automatic stay is something that really protects creditors and debtors, the courts take it very, very seriously. On that point, violations of the stay are considered to be void and can likewise create serious consequences for the creditor, kind of like what James was just referring to. So what that really means, not with respect to the consequences, but with respect to violations being void, if you engage in some action that violates the automatic stay, what is likely going to happen is the court is going to undo whatever that was. And that's really the first part of the analysis. Then the court figures out what are they going to do to the creditor for the violation.
Yeah, and it's not generally fun.
No.
There's not a party involved.
Exactly. Other courts consider the actions taken in violation as voidable. And the trustee can either seek to have the creditor found in contempt and fined, obtain a specific injunction under Section 105A, and likewise seek to recover attorney's fees, costs, and potentially damages. So not only are you likely not going to get your benefit of whatever action you took in violation of the stay, but you're also looking at potential attorney's fees and even damages as to either other creditors or the debtor. In most cases, innocent actions taken in violation of the stay may be voided, but they don't constitute grounds for finding the creditor in contempt. So there is some wiggle room there, but you never want to be anywhere close to the line on these issues. That's why we always tell people, when in doubt, just don't do it.
Yeah, that's better. That's good advice.
Where there's a violation that's considered to be a willful violation of the stay, Section 362H provides that the debtor may recover actual damages and, where appropriate, punitive damages. So this is a situation where it's bad enough that you're likely not going to get paid either at all or everything that you're owed by this person, but you could actually be looking at owing the debtor money, which really just adds insult to injury.
So let's look at the claim preparation just for a little bit. Again, this is presuming that you've been working with your customer's been buying from you, and all of a sudden you get a notice of bankruptcy. What do you do? So we would advise clients is to gather all the documents pertaining to that account and go ahead and start looking at it, right? Trying to figure it out. Look at the invoices, the delivery tickets, look for accuracy, make sure it's correct, make sure the payments, all payments received have been applied. And at that point, and most of the time, you may not be able to submit a proof of claim or claim to the bankruptcy court yet, initially, because if they don't have any assets, or it may not be time to do that. But get ahead of it, and there's a lot of reasons to do that. One is you may have lien rights if you're in a construction setting, that you could file a claim of lien on funds that are owed or on the property that you're working on. But again, you got to have specific information about the job, right, and what project that is, and hopefully you've got project accounts if that's the setting that you're in, or if you have a potentially reclamation claim or right, and that is to say to the bankruptcy court, hey, I want to get my materials returned to me, and so that's called a reclamation, and you have to act really quickly in the bankruptcy court to do that. We're not going to go into great depths of that today, but just realize that's a potential. So let's just say, for example, that you had material shipped to your customer on this like tomorrow, right? That you're shipping, say, $30,000 worth of material to them tomorrow, and on Monday you get a notice of bankruptcy. Well, in that case, more than likely you're going to have reclamation rights, but you got to act on them quickly to be able to get that back. And if you like wait and say, I'll look at it in 20, 30 days, because I know nothing happens in the bankruptcy court until 30 days later, you may miss out on the reclamation rights. Same thing on payment bond. If there's a construction job, if there's a bond, you might need to act on that quickly. So just think through that a little bit.
And you mentioned a claim of lien on funds. Is that something that you can file after the debtor has filed bankruptcy and not run afoul of the automatic stay?
That's a great question. So if you have lien rights or payment bond rights, absolutely. You may file your lien even after they file bankruptcy, but you have to stop after you do that. You can't do anything else at that point initially, but you can file your lien.
So no lien enforcement action or anything like
That's
that?
right. You can't go out there and take the property back. So if you drop ship materials on a job on Friday and they file Monday, you really shouldn't go back out there. In normal settings, we could talk about that offline. But if you're doing it in a bankruptcy setting, I would not go pick those materials up without bankruptcy permission. But that's a great question. So what about preference claims? What is a preference claim? What are they? How do you handle them? And what are the defenses that we got to look at? So a preference claim is this, y'all, and I want to explain this to you. And I remember the first time I started looking at this years ago, and I thought, this is crazy. So you've been selling your customer, they file bankruptcy, and then all of a sudden you get a letter from a trustee. Typically, just say it's a 90 days or 120, 180 days later after the bankruptcy. By the way, you got paid X number of dollars from the customer, the bankruptcy customer. You got paid $90,000 90 days prior to them filing bankruptcy. That's a preference. We want you to return that money. You go, wait a minute, I'm owed 100 and you want me to return 90 to the bankruptcy court? There ain't no daggone way. But that's what it says. So the definition of a preference claim is that it's a transfer. It says any transfer of property of the debtor. So it's, again, a transfer of property for the benefit of the creditor for an account of antecedent debt, which is a past due account owed by the debtor, made while the debtor is insolvent. And that is presumed. That is, that they don't have to prove it necessarily. You don't have to know about it. That is that there's a presumption that they're already insolvent 90 days before they file. So again, there's a transfer of some type of property to the creditor of a past due account made while the debtor is insolvent within 90 days of them filing bankruptcy, and the creditor receives more than you would have if there had been a liquidation. So those are 7 steps that the trustee actually has to be able to prove to say that that's a preference payment that you received. So again, I want to make sure you understand it. All of a sudden, everything's, things are going fine, or the customer may be a little bit slow in their payment, and then eventually you get a notice that they filed bankruptcy. And then later on, you get a letter from an attorney's office that says you owe us X number of dollars back to be paid to the bankruptcy court, because that's what they could consider to be a preference claim, that you got preferential treatment from the customer, from the debtor, right before they filed bankruptcy. And I'm gonna tell you, I don't think I've talked to a client yet, I've been doing this for a long time, that's ever happy to get that letter, ever. Everybody calls and they're outraged. Listen, y'all, we're outraged with you, but that's just what it is. So you got to deal with it, right? So knowledge that by the creditor, that the debtor is insolvent, you don't have to know that. That's not an element that they have to prove. The creditor has no knowledge generally, potentially, that the debtor is going to file bankruptcy, unless they come in and say, hey, look, I want to pay you because I'm filing bankruptcy next week. Do you really ever know that? They won't look, I love, really like you. You've been kind to me. I want to get you paid before I file bankruptcy. If you're having that conversation with your customer, please, please, please call me, call Ian, call some other lawyer, because there are other ways to get that taken care of without getting caught up in a preference claim, and it's lawful. So you got to do that, but they have to prove every element of that of a preference claim. So looking at the elements specifically, so It's every mode, direct or indirect, voluntary disposing of property, right? And I'm not going to go through all this stuff to the nth degree because it'll bore you to death. It's property of the debtor, right? That we've talked about. If a creditor's got to be involved, there's got to be a transfer of the property. A credit transaction is usually involved by definition because they're paying a past due payment, right, or past due debt. It's antecedent debt made while the debtor is insolvent. Again, that's presumed to be 90 days before they file bankruptcy. And then again, that's 90 days that they get to look back from the time they file bankruptcy. So the other question is, when is the date of transfer? So is it the date that you get the check? Is it the date that it clears the bank? Is it the date that they made the promise? So what does that look like? And there's several things that you could look at to try to argue that in a court, right? And again, the seventh element to that preference claim definition is that you are receiving more than you would get in a liquidation. And generally speaking, that's generally, it seems like, where it falls into place for the most part, because most of the time they don't have enough money to pay you. So what are the defenses? So how do you argue against that preference payment, right? They've got to prove all of, the preference must be proven before you get to the exception. So they've got to prove those 7 elements, and there's got to be a transfer of the property, and they've got to be able to prove all that stuff. So how do you defend it? So one of the defenses is called a contemporaneous exchange. That is, the customer comes in and says, look, I want to buy, $20,000 worth of material. Here's a check for $20,000. They take the material, they pay you the 20 grand. That's contemporaneous.
So that's not for a backward-looking debt that they are
Nope.
huge.
Nope, that's right. That's not, and they're not paying on the antecedent debt, right? But let's say, for example, that you've cut them off, right, on their credit account, and you're saying, look, I'll let you buy COD, but I'm not going to give you more credit. And they come in, order 10 or 20, whatever it is, $1,000 worth of material, write you a check for it, or give you cash or a credit card. That's contemporaneous.
So is it a good idea for creditors that sell goods on an account, if they start to get concerned about one of their customers, to maybe put them on a COD basis to avoid this issue?
Well, I can tell you, I bet if we did a survey right now, that happens a lot. And I know some creditors that tell you what, we're not going to sell you COD. We're just not going to deal with you until you get us paid. I'll tell you something else that's interesting, and we all have done. I know people that do this regularly. Let's just say, for example, they come in and pay. They need to buy the material, but they're going to pay part of that for the past due account, right? And then the other part is for the COD portion. So they may be buying $20,000 worth of material, but they're going to pay $25,000. So, but that $5,000 is going to be applied to the past due account. So, is that payment of $25,000 a preference claim, or is it a bifurcation? You have 5 goes to the past due account, and 20 goes to the contemporaneous exchange portion. I will tell you, I've seen trustees and their attorneys argue all 25 needs to come back to the court. But generally speaking, you can hopefully look at the account and say, well, 20 was for contemporaneous purposes, 5 went to the past due account. So,
and it's also a good idea to make sure that that's getting entered on your books correctly in the event somebody ever wants to take a look at it.
That's exactly right. Yeah. And that's why I have good records, right? So we're not going to go through all these examples on here because it'll wear us out. But again, it's contemporaneous exchange for payment. Another defense is called the ordinary course of business. And that's when the transfer is for payment of a debt incurred in the ordinary course of business, made in the ordinary course of business by the customer, and it's made according to the ordinary business terms. So, for example, the customer, you say your terms are net 30 days, and the customer typically pays, say, if you look back over, say, a 2-year period or whatever that period of time is, and they've been paying 35 days, right? Or they always pay 45 days. That's really where they fall in. Well, that's ordinary course, right? That's how you interact with each other. You expect them to pay you in 30, but they have paid you for 2 years, basically 45 days. Well, that's the ordinary course. And then you could look back and say, okay, out of that 90-day period, how much of those payments fell within that 45 days? That is a defense that you could use. Can you get dollar for dollar for that? Maybe, maybe not, but it gives you something. Does that make sense? So it gives you some defense to that payment. The intent of the defense is to allow ordinary and normal credit transactions, which are handled on a current basis, to continue on in that realm. So again, just to think through that a little bit, that just gives you a little bit. So there's also ordinary course between the parties. That is, how do these parties typically respond to each other? How do they normally deal with each other from a credit standpoint? Is it where account has been open long enough to establish that there's a history, you can go back and look at it. And the key here is that alleged payments must comport or comply with the normal practices. So we had a client who, oh my gosh, I'm horrible at spreadsheets. This client was amazingly awesome at spreadsheets. They would put in the payment history, they put in what those payments apply to, and they put it on the spreadsheet. And it was awesome because you could look at it and see how those payments apply, were to be applied. So it was really a cool thing. So it gives you something that you can look to and then make a great argument to the court. So, but being prepared is the key, right? So let's look at the next, so we get this thing here. Okay, sorry. All right, there we go. The code requires that it be ordinary. So again, that's argued and on both sides. Of course, the trustee is going to be arguing the opposite of what we argue. Thing is, you don't even want to get to the court to argue this really, but you want to use these defenses so that hopefully you can, in essence, negotiate it with the trustee's office, because they don't want to have a trial on this stuff either.
Right.
And then enabling loans is where the debtor acquires assets which serve as security for the loan. This doesn't happen too often with our type of clients, but it is available defense for you. And so if it happens, that's fine. And one other one that's really applicable to a lot of our clients is the new value, and that is where, for example, within that 90-day period, again, you don't know that because you don't know when they're going to file yet. But let's say, for example, the customer says, "Look, I need $45,000 worth of materials," and you go, "Look, you can't. Your credit limit, you will exceed your credit limit. I can't do that. I tell you what I can do is you can buy $45,000 worth of materials if you'll put that $45,000 down to be applied to your account, right? So there's a new value. You're giving new materials for the value of the payment. It's not the same as contemporaneous because they're paying for a COD. They're paying for the materials they're getting. This is, in essence, you're adding more to the account, but they're paying the account down so that the past due stuff comes off the books. So there's a new value defense there. And again, it's for money owed in goods, services, or new credit. So any new value given should be unsecured and may only be applied against the later transfers of assets. Also, one other one is a statutory lien. If you give up your lien rights, say for example, you say, you know what, I'm not going to file my lien because you've promised payment, and then they don't pay, then that's a defense that you get to use. Hey, look, I could have claimed a lien here, but I didn't because you promised payment, you didn't pay, so I lost my lien rights. So that's another. It's not a huge nail to put your hat on, but it is a nail. And there's also ordinary course in the industry. If this is sort of a last defense that you can use, that you looked at ordinary course with your customer, but then this is the ordinary course in the industry. And for several reasons, you got to get, quite frankly, you got to get an expert to qualify or to be able to give you this information. This one is if you're really going to go to trial. It's not as applicable to defenses outside of that. So what do you do when you receive a demand for an alleged preference payments, right? Do you do nothing? Do you respond to the letter? Because you're going to get the creditor is going to get the letter. Your lawyer probably won't get it, probably get it to the customer, to you, the creditor. Do you send them a check? Absolutely not. Call your attorney, take advantage of your defenses. Do not send them a check, because the letter that you'll get from the attorney's office is pretty straightforward. I mean, it's like, hey, send me the letter or else we're going to come after you. do not send them a check, because I have most of the case. We obviously can't promise you anything. I have very few cases where on a preference claim that you can't negotiate it down. So you've got available defenses, right? You want to use those.
So what would happen for a creditor that receives a demand where there aren't any defenses and the creditor is themselves not in a good position to repay the preference?
Go see your lawyer. Go talk, and we don't say that to protect us or our brethren, but go talk to the attorney, because that's a good analysis, a good question to ask. What do you do? You potentially could have you may have some defenses, right? And because you never know who's going to listen to this webinar later, so we're trying to be careful about exactly how you say it, but there's reasons not to go send the check, especially if you're cash strapped, right? You don't want to send a check initially because you potentially have preference claims or defenses that you could use. So, so what do you do? So if you're planning for a potential preference, so let's say, for example, your customer comes in and says, I want to pay you, I'm going to file bankruptcy next week, but y'all have been so good to me. I really want to take good care of you. Is there a way that payment could be made? Let's say, for example, the customer is an individual, is a corporation, right? Is there a way for that customer to pay you in another business, right? Potentially. Is it possible for the personal guarantor to pay you versus the company? If the personal guarantor is not going to file bankruptcy, could the personal guarantor pay you or guarantee pay you without the company paying you? Is it possible to go ahead and have them wire transfer, because that's immediate, and then hold off on filing bankruptcy for at least 90 days? So there's all kinds of ways of doing it, right? Or if they have another business that's not within that same business, if legally they can pay you through that potentially could avoid a preference claim. So there are lots of ways of avoiding the preference claim legally. You just want to make sure that you try to, some of it you're doing it somewhat blindly, so you're hoping that everything falls in place. But you can do that if you're careful with it. Does that make sense?
Yeah.
So again, what evidence of payment by the debtor of records to the trustees review? They go back and look at their accounts, right? They look at check. They look at now they're starting to look more at credit card companies' payments, because so many people are doing that. So there's all kinds of stuff they're looking to. The trustee, how long do they look back? They're looking back typically for the statute of limitations. It's a formula they're going to look at, and I'll be honest, if I tell you the formula, you'll never remember it, because we don't remember either. But the general rule is you got about 2 or 3 years, depending on when they file, when the trustee is appointed, if there is a trustee appointed, and when the final bankruptcy plan is confirmed. So it's not like it's 2 years from the date they file bankruptcy or 3 years. But generally speaking, it has to do with when the first trustee is appointed, or when the bankruptcy plan is submitted. So that just gives you an idea. We've had one case recently that we've held open for a while. It was fully resolved in the bankruptcy court, but we just were fearful that there was going to be a preference claim, and we feel like we've passed that time period, so we just went ahead and closed that file. But just realize that it's out there, right? And just make sure that you're not on the hook for too long, right? So you'll make sure that you're trying to protect that. So Ian, have you got anything else that you can think of that we haven't covered today?
No, I don't think so. The main thing to keep in mind is that obviously if one of your customers files bankruptcy, that's not the end of the road for anybody. But you do need to make sure that you're navigating the situation correctly, and not violating the automatic stay. And then also, if you've got a questionable customer, it's probably not a bad idea to talk to a lawyer about how to structure payments and just deal with that customer.
You mentioned something else that made me think about it. Let's say, for example, that you have a customer that files bankruptcy, but you don't get the notice, right? As a creditor, you don't get the notice. What do you do? But they filed because you've heard it in the street, right? You heard among your other creditors, or somehow or another you heard it, the salesman you already picked up on it, or somehow you know it, but you haven't actually gotten the notice. Are you still bound by that, by the bankruptcy code? So the answer is you got to be careful, right? If you know they file bankruptcy, and you actually are better off to play in the bankruptcy court with them versus sticking your head in the sand. Because if they may argue, well, we told you, we wrote you, we told you, but you didn't get it yet, right? So you don't know. But if they can prove that you did know later on, that's going to cost you pretty substantially. So you miss some deadlines that you potentially could use, right? So if you know they file bankruptcy, even though you don't get the notice, you want to stick your hand up and go, hey, I'm a creditor, right? Because sometimes the customers will say, I don't want to include you in the bankruptcy. And I've heard that story a bunch. And they'll go through the bankruptcy court and never explain to their attorney or to the bankruptcy court that this company, that they owe them money. And the reason is they want to pay them, right? Because they've been nice to them.
Right. And they potentially need to continue doing business just to try to maintain operations. But that's not really a good situation for anybody. It's a really bad situation for the debtor. It also potentially creates problems for the creditor they were trying to help.
Yeah.
So bankruptcy is not an area where you want to get close to any lines on, and you've got a trustee that's going to be looking at most of this stuff, so it's better just to play out in the open. That way, if anybody does ask any questions, there aren't going to be any issues.
Yeah, and then one other thing that we would encourage you to do is, if you don't participate in the bankruptcy, guaranteed you're going to lose. You just are. If you're a secured creditor, you definitely want to play in it. If you are an unsecured creditor and they have no assets, we get it. You don't want to spend extra money trying to make sure that you don't lose any more. And there may not be anything to be able to do in the bankruptcy, but if you don't participate, you definitely don't win. And so this has happened often, or several times, where we've seen a company or person file for bankruptcy. They get in it and then they realize what they've got to do to get the debt either discharged or rescheduled. And all of a sudden they go, you know what? I don't want to do this. And they don't participate and they get kicked out of bankruptcy. If you don't follow them, you're going to presume that your debt is discharged and that you can't go after them. But if they've gotten kicked out of bankruptcy, dismissed, the debt is still there. You can still go after them. So, you want to make sure that you keep up with that.
And at that point, if they do get dismissed, it's kind of a race to whatever assets are available. So you want
That's right.
You want to be ready to go in that situation.
Yeah. Well, hopefully this has been helpful to y'all. If you have questions, please let us know. And again, we'd love for you to connect with us on social media stuff if you haven't already. Look forward to participating with you on our next webinar on the 25th of June. And y'all look out for the podcast. We're going to do our best and see what that looks like. So thank you so much.
Yep, thank you.